All right. Good afternoon, everyone. My name is Christopher Cahill. Thank you for joining us. I'm really excited to be here with you today to share essential legal documents that every family needs. My co-contributor and speaker today is Andrew Butler, partner at Archstone Law in Massachusetts here. And Andrew, say hello to everybody.
Hi, everyone, and thanks, Chris, for the introduction. Really excited to share this topic with everyone today. Some kind of updates on some kind of recent developments, but then also just kind of an overview of estate planning and kind of the legal documents that entail a comprehensive estate. So, looking forward to a nice discussion today.
Perfect, thank you. And we're going to do our best to be judicious with time here. So we'll get through this material. Please, if you have any questions, post them in the chat. We'll do our best to answer them. And if for whatever reason we are not able to get to them today, please just reach out to me, and I'll make sure to either follow up directly myself and/or with Andrew. So again, my name is Christopher Cahill. I run the Family Office Services Group here at 12 Points. I'm an attorney, certified financial planner, and a chartered advisor in philanthropy. And I no longer practice per se. I don't draft documents, but I've spent my business life on high-end trust and estate planning. So I did draft documents for quite a period of time, but more often than not, I'm brought in as a consultant and an architect, if you will, to help develop and implement comprehensive estate plans for families throughout Massachusetts and the country. So, what we're known for here at 12 Points is helping our clients define, discover, and live out their freedom, whatever that may be. And more often than not, that's kind of taking care of the ones you love, the causes you care about, and making a lasting difference in the world. So we're really pleased, as I said, to have our friend Andrew here, who's a really talented trust and estate attorney. So Andrew, let's kind of just get right into the heart of the matter here. So let's talk about core documents. When people say you need legal documents, what are they talking about?
Right. So when I talk to my clients about estate planning, I sort of start with the core documents and sort of build from there. So and those core documents are really addressing two main issues. So the sort of disposition of assets at death, and then also planning for the possibility of incapacity during lifetime as a result of accident, illness, something of that nature. So we always want to get those kind of basic building blocks in place. And then for clients who have sort of a higher level of needs, we can build from there with potentially things like irrevocable trust or perhaps special needs planning, different sort of aspects. But always want to start with the basics, get those in place, and then if you need something more, can have that conversation and put those pieces in place as well. So basically what we're talking about in terms of the documents themselves are wills, revocable or living trusts, powers of attorney, healthcare directives or healthcare proxies, HIPAA releases that go with those, and we're going to get a little bit into irrevocable trust, although that's sort of that kind of next level up, but so we'll just touch upon that today.
Perfect, thank you. Sorry. So let's touch on the modifications to the Massachusetts estate tax that happened last year.
Yeah. So so definitely sort of still in the news a bit, although overshadowed by what we think are going to be some changes with the federal estate tax, which we'll get to next. But for those of you here in Massachusetts, where I'm based, for years we had a $1 million estate tax exemption, sort of forever, and we were sort of a lagger in the country.
Let's be honest, woefully low, right?
Yes. And thankfully, we got some relief last year. It bumped up to $2 million. I apologize for some background noise here. I had an unexpected flight today, so I'm sitting at Logan Airport. So if you hear some gate announcements, I apologize. But nonetheless, Massachusetts state tax exemption is now $2 million, up from $1 million. In some ways, the biggest change, and this is for married couples, they took it in a way where it used to be that you really, even for a married couple, you really only got $1 million of exemption, and now with proper planning, you can get $4 million. So in my mind, for married couples, it was really a change from 1 million up to 4. So I think the focus has been on the 1 to 2, but if you're married, the benefits of planning are that much more valuable now because you can get a full $4 million exempt from estate tax. We've gotten more and more clarity for people who either live in another state and have property in Massachusetts or live in Massachusetts and have property somewhere else. Still a couple lingering questions there, in particular if you own real estate not in your own name but through an entity such as an LLC. So still hoping for a little bit more direction on that. So that's Massachusetts. And then on the federal side, we've sort of been like, a little bit on edge, wondering what was going to happen with the election. And for a lot of reasons, but in my world, the reason we were on edge is we didn't know whether some of the tax provisions that were scheduled to sunset the end of next year, whether, as a result of the election, maybe something would change. I think given, and I think I just saw this morning that they called the House for the Republicans as well. I think now with the Republicans in control of, White House and both houses of Congress, pretty clear that we're not going to have sunset. There's a number of tax provisions that are going to expire at the end of next year. The one that's most relevant to our discussion today is the federal estate tax. The exemption was going to drop essentially in half from about 14 million per person to roughly 7. Suffice it to say, there's not going to be a sunset. I think it's really just a question, do they push the sunset out another, 5-10 years? Do they just make it permanent? I think there's even a pretty good chance that they just decide to repeal the federal estate tax altogether. It may not be a sudden thing, might be over time. So stay tuned. But I think it's safe to say the federal estate tax the exemption will not be, the sun will not be setting on that at the end of next year. So.
And I'd be inclined to agree with you on most of that as well, Andrew.
Yeah.
We do a lot of planning with families with significant wealth that are subject to estate tax currently and would be more so under the sunset. It will be interesting to see where things go. The reality is that I think it's very clear that those provisions of the Tax Cuts and Jobs Act will be extended at a bare minimum, maybe improved and or possibly eliminated altogether. So, stay tuned. That'll be a further conversation as we go forward, but not necessarily important to everyone by any means, but to the people that it is important to, it's really important because
Sure.
current estate tax rate is 40% for assets over the exemption amount.
Yeah,
So,
I mean, one thing we can be sure of, Massachusetts will not be getting rid of their estate tax. So if you live in Massachusetts, good news, we've increased the exemption. Federal estate tax probably going away or something close to it. But, if you live in Massachusetts or have property here, still need to be aware of that in your planning.
right, and let's be honest as well, that's part and parcel of what's driven a little bit of the exodus from Massachusetts recently too, as has the Massachusetts millionaires tax that came in. So two of those combined have made Massachusetts, less attractive to wealthy folks. And as a result, people are leaving Mass to go to other jurisdictions, whether it's Florida, Texas, whatever. So
Yeah.
we see that quite a bit, and I'm sure you do as well, right?
Yeah, I certainly see that in my practice, and just talking to colleagues anecdotally, I've heard, a number of people are, either at least, if not completing, kind of the exodus, at least starting to look into it and seeing what that might entail. And from an estate planning standpoint, what I often say is that estate planning is sort of 80% non-state specific, but probably 20% state specific. So if you've done documents here in Massachusetts and you sort of get serious about establishing residency somewhere else, Florida, wherever it may be, once you get down there or start that move, you're going to want to talk to an attorney in whatever jurisdiction that is. Have them look at your Massachusetts documents. They may be able just to make some changes. It may be necessary to just redo them and have them be, say it's Florida, have them be truly just like Florida documents through and through. So, but that's sort of a case by case basis. But at a minimum, you'll want to talk to somebody in that jurisdiction.
So let's just talk about the good old fashioned will here, right?
Yeah, yeah. I think this is certainly a document. People hear the term estate planning. I think most people think of a will, and probably the scene in the movie or the TV show where the stodgy old attorney with the tweed jacket and the pipe, is reading the will. We don't really do that in the real world, but makes for good entertainment, I guess. So, but more serious note, will is certainly an important part of any estate plan, and it really accomplishes a few things. So one, it provides for distribution of assets. Now, it could just be that it's sending assets to a trust, which we'll get to next, in which case we refer to that as a pour over will. It sends probate assets to the trust. But in this more simple will, it actually would very well state where the probate assets go. Okay, it's also where if you have minor children, you would appoint a guardian or guardians for them. Very important for people who have young children. And it's also where you name what we now call personal representative of the estate. People are more familiar with the term executor. Means the same thing, but that's just the terminology we use. That's the person in charge of administering the estate, making sure that final medical bills, funeral expenses get paid, tax returns get filed, assets get where they're supposed to go. Somebody in that role certainly would get professional help, but it's usually a family member with some professional assistance. One just quick point I want to make though on wills is that I think earlier I used the term probate assets. It's an important distinction that a will only acts on probate assets, meaning assets that we can't look at when somebody dies and know where they're supposed to go. So assets that are jointly owned, say by a married couple, or assets subject to a beneficiary designation, such as a retirement account, whether it be IRA, 401k, 403b, or life insurance. Those generally have a beneficiary, and so we look at the beneficiary designation to see where they go. So a will only operates on assets that we can't sort of look at the face of them and know where they go. So a bank account in one person's name, an investment account in one person's name, a home that's not jointly owned. So things like that, interest in a business. So just an important distinction between probate versus non-probate.
Great, thank you for that. And one of my all-time favorite documents here, a revocable or living trust.
Yeah, yeah. And sometimes people put them together and say revocable living trust. So, so whatever, kind of whatever floats your boat. But so yeah, I mean, trusts are arguably, kind of one of the more powerful, sort of legal documents that are sort of available to us. Can really do a lot of things. There's also things that there's some misconceptions out there about things that they can do or help with that they really don't. So, for instance, they really don't help in terms of asset protection. They don't help in terms of somebody who's looking to put assets, protect assets in the event they go into a nursing home. So irrevocable trust can help with those things. But what we're talking about is a revocable living trust where you set it up during your lifetime. You can put assets in there during your lifetime, which you still have full control over, still considered yours. But by doing that, it allows you to avoid that probate process I mentioned before when I was talking about the will. It's a way of converting probate assets into non-probate so that we can avoid the probate process where we have to file a will with the court, some other documents, pay court costs, legal fees, spend time, and some aggravation. So a living trust is a very valuable tool to avoid that. It's also an important tool for estate tax planning. I was talking earlier for a married couple, the ability to shelter $4 million from the Massachusetts estate tax. That can really only be done by using a revocable trust. Otherwise, you only get $2 million of exemption. And also, a trust is a way of allowing you, instead of having assets go directly to beneficiaries at your death, to perhaps have them stay in trust for a longer period of time to provide an element of control and protection for those. So if you have young children or just even adult children, you maybe have concerns about, what would happen if they came into a lot of money all at once. It's a way of kind of pushing that timeline out. So again, trust can do a lot, but a revocable trust can do a lot. But just to be clear, sometimes there are certain things that they can't do. So you just have to be careful when you're talking to somebody about it.
Yeah, and one thing I always like to add here as it relates to the revocable trusts is just the importance of, if you spend the money with an attorney like Andrew to do them, for God's sake, let's make sure that we put assets in there and that we fund them, right? Because the last
Yeah.
thing and the worst thing, and we see this all of the time, is people spend thousands and thousands of dollars to do great legal documents, and for whatever reason, they fail to do what we call funding the trust. So
Yeah.
that means simply moving the assets into the trust, because
Yeah.
absent that, you got to go through probate, and that defeats the whole purpose of this. So
Yeah.
that's
Yeah.
topic
For
one.
For sure. And also, you also sort of in that same point, it's also important to sometimes it makes sense to name a trust as a beneficiary of whether it be a retirement account or an insurance policy. So you also want to make sure that you're coordinating those beneficiary designations with your revocable trust if you have one. So yeah, really, really important point, Chris.
And then the last one that I'll bring up on this before we proceed is there just seems to be a real benefit to using revocable trusts for purposes of incapacity. So as Andrew discussed, I mean, it's wonderful for distributing assets at your death, but should you become incapacitated, your successor trustee, in essence, steps into the role. Well, they do step into the role as trustee, and they serve as your alter ego. And if you need to go and deal with financial assets, and move things around, buy things, sell things, distribute things, being that successor trustee to a revocable trust is a really great way for managing assets for an incapacitated individual, as opposed to simply relying upon the durable powers of attorney that we're going to discuss now. You should
Yeah.
still have a durable power of attorney. This doesn't mean that you shouldn't, but just for whatever reason, my experience has been, and others have also seen this as well, that financial institutions really struggle with powers of attorney, and truthfully, they'd prefer to not see them. I always joke that, when you show up to the bank with a power of attorney saying, "Hey, I'm here to deal with my Aunt Susie's assets," they're going to find any number of reasons to not allow you to do that. But if you show up at the bank with the trust document that says, "I'm successor trustee to Aunt Susie," they're going to give you cookies and a cup of coffee and ask how they can help you. So let's talk about what these powers of attorney are and aren't.
Yeah, so we'll set the context here. So power of attorney is designed to allow someone, being the, consider them either the agent or the attorney in fact, to act on behalf of the principal, as the person who's sort of, signing the document. So it's allowing somebody to sort of step into your shoes if you need them to. And people may be familiar. You may have had like a real estate closing. You didn't want to go in person, so you gave somebody, sort of a limited or special power of appointment to act on your behalf at the closing. Um, it could also be, maybe a little bit broader, but still not comprehensive. So what we call like a non-durable power of attorney. But for estate planning purposes, really the gold standard and the document you should be putting in place is what's called a durable power of attorney. The other powers of attorney, if you become incapacitated, then that agent is sort of, in essence, deemed incapacitated as well. They stepped into your shoes. So if you can't act, they can't act. A durable power of attorney, which is created by statute in every jurisdiction, means that the power of attorney survives the incapacity. So even though you're incapacitated, the power of attorney, the person you've designated, can continue to act. So very helpful in a situation where, you're in an accident, very sick, maybe later in life, something like dementia, where, mentally and or physically you can't keep up with your day-to-day affairs, things like paying your bills, filing your tax returns, dealing with the business you're involved in. So all the things that ordinarily you've got to show up in person and do, you've got to sign for something, you're allowing somebody to do this. So very important to have this document. The alternative is somebody actually may have to go into court and get appointed as your guardian or conservator. That's expensive, it takes time, and there's a degree of uncertainty. You can't be guaranteed who will actually get appointed. So this is a way for you to take control over who you want to take over for you during a period of incapacity. So So, various, extremely important part of an estate plan. Um, Similar context, but you need somebody to be able to act for you to make medical decisions. In Massachusetts, this document is what's called the healthcare proxy. The person you name in is your healthcare agent. So if you require medical attention and you cannot express your wishes regarding your care, your healthcare agent becomes your voice. So very important that um, the people you name in it know what your wishes are. They're really supposed to carry out your wishes, not simply impose their own feelings, which might be different because we're potentially talking about end of life decision making. So, um, not easy conversations to have. Understand that, but very important that you chat with your healthcare agents, let them know what you want, and maybe you even want to put that in writing through something sometimes referred to as a living will or advanced medical directive. Those are not those don't have legal effect in Massachusetts, but they certainly carry a lot of weight and obviously make your healthcare agent's job easier if you've put this in writing. But I think kind of the gold standard is, have the healthcare proxy and then have the conversation and perhaps kind of those written directions as well. And then one other companion document is what's called a HIPAA release. So there's regulations, probably all sort of painfully aware of them every time you go to the doctor about patient privacy, and you've got to sign a HIPAA form and all kinds of things. So when you sign the healthcare proxy, make sure that either the healthcare proxy has the HIPAA language or there's a separate document. That's the way I do it in my practice, a HIPAA release that just makes it clear that medical providers are free to share your personal medical information with somebody serving as your healthcare agent. So again, important documents to have in place.
Yeah, I would just add in there, Andrew, thank you, that, the reality is that absent that HIPAA authorization and release, you might give somebody the ability to make decisions for you, but they might be in the box where they can't really
Yeah.
get educated as it relates to the specifics of your situation, which really would be tragic, honestly.
Yeah,
So
yeah, no, absolutely. Yeah, no, you really either need to have the separate HIPAA release or have the HIPAA release language built into the healthcare proxy. So either one is fine.
thank you. So my next favorite document is the irrevocable trust.
Yeah.
Discuss what they are, what they aren't.
Yeah. So again, we talked earlier about revocable trust. Again, created during lifetime, funded during lifetime, but you have full control over them. And again, they can help avoid probate, help with estate tax planning, and also provide for management of assets during a period of incapacity, and sort of extend the timeline for beneficiaries. Irrevocable trust, also sort of potentially multi-purpose documents. Um, I would say the main advantage of them is a way of putting assets out, getting assets out of your estate for estate tax purposes, and that's particularly valuable in Massachusetts because we don't have a gift tax and we don't have a add back of assets at death. So every asset you get out of your estate during your lifetime is one less asset you're potentially paying estate tax on. So it's a great way, it's kind of a way of getting assets out. Um, some people, the concern there is, obviously once you've given it away in an irrevocable trust, you can't get it back. So for married couples, what we sometimes do is create a special kind of irrevocable trust called a SLAT, which stands for Spousal Lifetime Access Trust. So one spouse can put the assets in there. They no longer have access, but their spouse would have access, sort of in a kind of a more emergency situation during their lifetime. So provides a little bit of flexibility, a little bit more feeling like you haven't put it totally beyond your reach, as long as kind of stay on good terms with your spouse, for sure. So they're a great vehicle. They can also be used somebody who's looking to do sort of nursing home or kind of Medicaid planning. So again, but there's some look back rules on that, so you have to really be, kind of doing that well ahead of time. And 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 then the last point is irrevocable trust. I would say the asset we put into them most of the time is actually life insurance. So life insurance, even if it's term insurance where it has no economic value while you're alive, is considered part of your estate for estate tax purposes. But it's because most people own the policies in their own names. But if you put the policy into an irrevocable trust, um, and in those situations, we often refer to it as an ILIT, irrevocable life insurance trust. Then that policy is out of your estate for estate tax purposes. So really powerful tools, but because of the irrevocable nature, you want to just really think through it, really discuss it at length with your attorney before you pull the trigger on it.
Yeah, and as Andrew indicated, this is really level 2.0. I mean, when we talk about estate planning documents for the average client, it's that core set of docs: the will, the revocable trust, healthcare, durable. Oftentimes, if there's insurance, we do like to utilize the IREV trusts for that. But there's so many different flavors and iterations of these that we're just barely touching on the surface of them, to be honest. But for wealthier clients with more complex situations, IREV trusts can and are a facet of planning that we utilize and rely upon all of the time. So if there's anything that's piquing your interest here and you want to discuss more, by all means, please do. But in the interest of time today, we're going to move on to, we're just going to touch briefly on a prenup and a postnup, because these are things that we talk a lot about. Many people just don't do them, to be honest, but let's just kind of run through it real quick, Andrew.
Yeah, so I think a lot of people, I mean, there's sort of a focus in estate planning on like what happens to your assets at death, but I think also it's important to protect those assets during your lifetime. So so I definitely kind of to Chris's point, I definitely talk to a lot of clients about prenuptial agreements, but I'd say maybe a third of people I talk to them about them actually do them. But really, the idea is to, I mean, it certainly doesn't sound like the most romantic thing, ahead of a marriage. But the idea is that you're sort of entering into a relationship, maybe in the same way that you might be starting a business with somebody, and the idea is that you expect it to be successful and last forever. But if it doesn't, let's decide ahead of time, what the breakup would look like, how things would be divided up, and in a divorce, there's marital assets and separate assets, and so a prenuptial agreement will sort of define what's going to be considered marital property that will be divided and separate property that will kind of return to the original owner. Prenup's going to also address, debts, and maybe if there's a home, how things will be split up. It'll talk about assets that are inherited during the marriage, received as gifts. So it's going to kind of cover everything. Also, maybe how expenses are going to be paid during the marriage. So it can be pretty comprehensive. I mean, I think typically the starting point is to say, what I bring in, I'm going to take out. What you bring in, you're going to take out. Everything else we kind of split. But that's at a very simplistic level, and that's just like sort of a starting point. Every agreement is going to be different. But the idea is to kind of make your make your arrangements ahead of time so that you're not having to negotiate it. In the heat of a divorce where emotions are high and attorney's fees are high, so much cheaper to do it up front.
And to that end of talking about doing it in advance, the reality with these documents is that they're useless if you sign it the day before the wedding.
Yeah.
So what I would suggest, what we would suggest is, to the extent that you're contemplating one, and more often than not, it's people with a second marriage that got burned through a first marriage, let's be clear, or it's parents of wealth that want one for their children.
Yeah,
So
that's right. That's where I see it the most. Yeah.
yeah, what we don't want to do is have it happen the day before. We need time in advance, and we really need to be able to make sure that there's what we call full and adequate disclosure of the assets. So absent that, the document can be set aside. So, you really want to make sure that any of the planning that you're doing is going to bear fruit the way that you want it to. So those last minute prenups aren't worth the paper they're printed on, honestly. So just keep that in the back of your mind. And boy, we got a lot on prenups here. We're going to skinny this down for next time because, as we said, most people really aren't doing those. Let's talk briefly about post-nuptial agreements, though, because I think that's probably something that warrants a small discussion here.
Yeah, I don't don't see too many of them, but you do have the option if you didn't kind of get around to the prenup, you were too busy planning the wedding and the honeymoon, and you decide later on you'd like to have one. You can do a postnuptial agreement. The requirements are a little stiffer. They're this is kind of the standard for enforceability is higher. So it's a little bit. I mean, it can be done, but it's sort of it's a heavier lift. The the on a prenuptial agreement, the assumption is that it's valid, and a party contesting it has to show why it should be thrown out. Whereas a postnup, it's the opposite. It's sort of assumed it's not valid, and the burden is on the party that wants it to be enforced to sort of prove why it is enforceable. So much better to do it ahead of time, but you really need to do one afterwards. It can be done. Just expect it's going to be a little bit harder to get there. So.
And anytime I've seen those post-nups, it's generally precipitated by an event in the marriage that created one party to look at the other one in a different way. And there's some significant compensation flowing back and forth for maybe some actions that were taken. So
Yeah.
just hopefully you don't need to find yourself, or you don't find yourself in that position by any means. So again, the objective today was to cover the basic legal documents that you as an individual or family member would need. I think we've done that really well here. Andrew, I really appreciate you taking the time as always.
Of course.
This is where you guys can find me. Reach out with any questions. Chris at 12pointswealth.com. And Andrew's material is here. He's got a QR code, so by all means scan that with your phone. Otherwise, you can get at 781-314-0113. Butler@archstonelaw.com. So Andrew, always a pleasure. Great job today. Have a safe trip. Best to the family.
We still have a few minutes, so if you want to come and see me here already now, and we can drink.
Thanks so much, Chris, and take care, everyone. Thanks for your time today.
Thank you. Bye-bye.
Bye-bye.